Peace and blessings, everyone. I'll read something to you. Involuntary manslaughter. Involuntary manslaughter, sometimes called criminally negligent homicide in the United States, gross negligence, manslaughter in England and Wales, or culpable homicide in Scotland, occur when there is no intention to kill or cause serious injury, but death is due to recklessness or criminal negligence. Recklessness. Recklessness or willful blindness is defined as wanton disregard for the known dangers of a particular situation. An instance of this would be a defendant throwing a rock off a bridge into vehicular traffic below. There exists no intent to kill. Consequently, a resulting death wouldn't be considered murder. However, the conduct is probably reckless, sometimes used interchangeably with criminally negligent, which may subject the principal to prosecution for involuntary manslaughter. The individual was aware of the risk of injury to others and willfully disregarded it. In many jurisdictions, such as in California, if the unintentional conduct amounts to such gross negligence as to amount to a willful or depraved indifference to human life, the mens rea may be considered to constitute malice. In such a case, the charged offense may be murder, often characterized as second-degree murder. Willful blindness. Willful blindness, sometimes called willful ignorance or contrived ignorance, is a term used in law to describe a situation in which an individual seeks to avoid civil or criminal liability for a wrongful act by intentionally putting himself in a position where he will be unaware of facts which would render him liable. For example, in a number of cases, persons transporting packages containing illegal drugs have asserted that they never asked what the contents of the packages were, and therefore lacked the requisite intent to break the law. Such defenses have not succeeded, as courts have been quick to determine that the defendant should have known what was in the package, and exercise criminal recklessness by failing to find out before delivering it. A famous example of such a defense being denied occurred in In re Amster copyright litigation, in which the defendants argued that their file swapping technology was designed in such a way that they had no way of monitoring the content of swapped files, and suggested that their inability to monitor the activities of users meant that they could not be contributing to copyright infringement by the users. The court held that this was willful blindness on the defendant's part and would not constitute a defense to a claim of contributory infringement. Criminal negligence. In criminal law, criminal negligence is one of three general classes of mens rea, Latin for guilty mind, element required to constitute a conventional as opposed to strict liability offense. It is defined as careless, inattentive, neglectful, willfully blind, or in a case of gross negligence, what would have been reckless in any other defendant. To constitute a crime, there must be an actus reus, Latin for a guilty act, accompanied by the mens rea, see concurrence. Negligence shows the least level of culpability, intention being the most serious and recklessness of intermediate seriousness, overlapping with gross negligence. The distinction between recklessness and criminal negligence lies in the presence or absence of foresight as to the prohibited consequences. Recklessness is usually described as a malfeasance, where the defendant knowingly exposes another to the risk of injury. The fault lies in being willing to run a risk. But criminal negligence is a malfeasance or nonfeasance, where the fault lies in the failure to foresee and so allow otherwise avoidable dangers to manifest. In some cases, this failure can rise to the level of willful blindness, where the individual intentionally avoids averting to the reality of a situation. Note that in the United States, there may be sometimes there may sometimes be a slightly different interpretation for willful blindness. The degree of culpability determined by applying a reasonable person standard. Criminal negligence becomes gross when the failure to foresee involves a wanton disregard for human life. See the discussion in corporate manslaughter. The test of any mens rea element is always based on an assessment of whether the accused had foresight of the prohibited consequences and desire to cause those consequences to occur. The three types of tests are: 1. Subjective, where the court attempts to establish what the accused was actually thinking at the time the actus reus was caused. 2. Objective, where the court imputes mens rea elements on a basis that a reasonable person with the same general knowledge and abilities as the accused would have had those elements. Or 3. Hybrid. That is to say, the test is both subjective and objective. The most culpable mens rea elements will have both foresight and desire on a subjective basis. Negligence arises when, on a subjective test, an accused has not actually foreseen the has seen the potentially adverse consequences to the planned actions, and has gone ahead, exposing a particular individual or unknown victim to the risk of suffering injury or loss. The accused is a social danger because he or she has endangered the safety of others in circumstances where the reasonable person would have foreseen the injury and taken preventive measures. Hence, the test is a hybrid. What is a reasonable person standard? This is not a real person but a legal fiction, an objective yardstick against which to measure the culpability of real people. For these purposes, the reasonable person is not an average person. This is not a democratic measure. To determine the appropriate level of responsibility, the test of reasonableness has to be directly relevant to the activities being undertaken by the accused. What the average person thinks or might do would be irrelevant in a case where a doctor is accused of wrongfully killing a patient during treatment. Hence, there is a baseline of minimal competence that all are expected to aspire to. This reasonable person is appropriately informed, capable, aware of the law, and fair-minded. This standard can never go down, but it can go up to match the training and abilities of the particular accused. In testing, whether a particular doctor has misdiagnosed a patient so incompetently that it amounts to a crime, the standard must be that of the reasonable doctor. Those who hold themselves out as having particular skills must match the level of performance expected of people with comparable skills. When engaged in activity outside their expertise, such individuals revert to the ordinary person standard. This is not to deny that ordinary people might do something extraordinary in certain circumstances, but the ordinary person as an accused will not be at fault if he or she does not do that extraordinary thing, so long as whatever that person does or thinks is reasonable in those circumstances. The more contentious debate has surrounded the issue of whether the reasonable person should be subjectively matched to the accused in cases involving children, the person with a physical or mental disability. Young and inexperienced individuals may very well not foresee what an adult might foresee. A blind person cannot see at all, and an autistic person may not relate to the world as a normal person. Cases involving infancy and mental disorders potentially invoke excuses to criminal liability because of the accused's lack of full capacity. And criminal systems provide an overlapping set of provisions which can either deal with such individuals outside the criminal justice system, or, if a criminal trial is unavoidable, mitigate the extent of liability through the sentencing system following conviction. But those who have ordinary intellectual capacities are expected to act reasonably given their physical condition. Thus, a court will ask whether a blind, reasonable person would have set out to do what the particular blind defendant did. People with physical disabilities rightly wish to be active members of the community, but if certain types of activity would endanger others, appropriate precautions must be put in place to ensure that the risks are reasonable. Going by those guidelines of what I just read, I find guilty all governments and individuals who support capitalism guilty of involuntary manslaughter. For in the system of capitalism, apathy, greed, and indifference are allowed, and they are nurtured, justified, and accepted. And in apathy, greed, and indifference, there is suffering, pain, and death. God bless. Peace and love.